I also studied in Delhi. I did my law from there. I finished in the 9. Thereafter, sometime in Bangalore, in Delhi, and then in Gauhati. I was in Gauhati for 7 years, up to 98. 8 years. And thereafter, I shifted here. Since when are you there in Gauhati? On transfer or when the fish and when the Delhi. Acha, 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 acha. And then selected to be the selection. Salary must be good.
So,
Yeah.
depending on semi-common place
Acha,
but
acha.
some common place
Then why you have shifted to Assam? Correct.
After 3 years, they will review all the contract and after passing more 3 years, we have to appear once again test. And that's pure genuine. Sometimes your love will not work.
Yeah.
So it will have to be your.
So you wanted to be secure.
Yes. This is the main reason. I want to family because of family. But anyway, we have to adjust.
And
This is the only way to do it.
nowadays, Delhi and Gauhati, there is no problem for traveling
Yes.
either by air, by train, it's very convenient. In fact, traveling from here to our village will take more longer time
Yes.
than traveling between Gauhati and Delhi.
Yeah.
Yes.
You have decided and.
Yeah.
That's right. Because some uncertainty in happening like this is for the world. No one will challenge. After telling so my name it's a
I think you have adopted a very good principle. Once you can understand that, rest are automatic. Everything is correct. Correct. We should make life more lively. Huh? We don't know how long it will be. So we should live a meaningful life. Yeah. We should live a meaningful life. Yeah. That's right. It's not very yeah. It's so
So where would be it done?
Yeah, sir.
Sorry, I kept you waiting for some.
Oh, no problem. We have enough time, Lordship.
Yes.
Please, O Lordship. As I have mentioned yesterday, Lordship, my submission will be shorter than my learned friend. And while reading the judgments, I will also pause and reply. And whatever I would like to submit, I would like to proceed in that manner. In that case, the moment I stop, I finish reading the judgment, then my submission will also be over automatically. So in that manner, I would like to proceed. As Lordship may have observed, during the last 2 days of hearing, there has been a lot of discrepancies in the numbering the cases, who was plaintiff, who was defendant. It was
procedures.
Yes, procedures. Admittedly, those are the things which has been committed, and we have to accept that as a fact, Lordship. Because what has happened, we cannot make it unhappen.
When this
Cannot-
impugned judgment was passed?
The present judgment,
Yes.
this was passed on 17/5/2019. Lordship will find it page 151. Before Lordship want to put any query on that?
And no, judiciary and executive were separated here in Nagaland.
After the separation,
This judgment was
Yes.
after separation.
yes. When the judgment was passed, it was under the supervision of this honorable court. Now, my learned friend has made a lot of submissions by relying on the evidence and depositions, which was met before the additional deputy commissioner PAC. That was in the earlier proceeding. In the initial stage of his submission, he has made a submission that this order is already quashed. That is true. The impugned order, the order passed by the additional deputy commissioner judicial way back in 2005, that has been quashed on the ground of the evidences were not properly used, all these things. So once the judgment goes, all deposition, everything automatically goes along with the judgment. I do not know why
Which judgment was quashed?
it was on 28/11/2005. This is the order passed by the additional deputy commissioner Kohima, additional deputy commissioner within bracket judicial. That was the nomenclature used earlier. The district judges were all ADCJ. So it
This
was.
judgment is also there in the appeal memo.
Yes, I'll come to that.
Okay.
And then this judgment of 28/11/2005, that is page 69, this has been set aside by judgment dated 10/7/2017, annexure G, page 77 of the appeal.
By judgment date annexure.
Annexure A,
Page-
page
page-
69 is the 2005 judgment. And Honorable High Court judgment is annexure G, page 77. Judgment dated 10/7/2017, page 77, annexure G. By this judgment, the order passed by the learned ADCJ, which was passed on 28/11/2005, has been quashed. Therefore, what I'm trying to apprise the Honorable Court is all the depositions, evidences, whatever has taken place before the ADCJ, PAC and Kohima, because PAC and Kohima is a continuation. During the,
The judgment was by Kohima.
yes, exactly, Lordship. Deposition, everything has been recorded in PAC, and thereafter it was transferred to Kohima, and it was heard in Kohima,
Delivered by Kohima.
delivered by Kohima. This judgment has been quashed by this honorable court on 10/7/2017. Therefore, in view of quashing the judgment of this by this honorable court. All deposition, everything goes. Judgment is also not there. And whatever documents, evidences were there, depositions, it's all automatically gone. Therefore, I fail to understand what was the necessity for referring and relying on those depositions when all this has been already quashed by this honorable court. Now, before coming to my submission, little background how the case started, how I also got, what is the possession of the land, I would like to brief. And for the convenience of all of us, I have prepared a sketch map. This is on drawn because we are referring to the documents,
Yes.
this land, this side, that side, but we have not seen. So to have a bird's eye view about the location of the land, where it is located, I have drawn. The map is not to the scale, but for our convenience, I have drawn to show the area of the land. And Lordship may hold it in a horizontal manner because it will be more convenient to refer to that. By giving that, I would like to point out the yellow one is the suit land, 24 by 12. 24 feet is facing the main road. It is a commercial area. 2 shops are running at present by the appellant.
This is town area. It is town area in.
Yes, heart of the town. This is the middle of the
Prime
Buchoro town.
location.
Yes. So I do not know how much rain my Leonard friend is getting, but this is this suit land, and Lordship will find town road, and then towards the
Police point.
police point is in the middle, and on the extreme right, that is the A side, and Sanyus land is shown just next to the Kiritis land. And then one road leads to Kohima, that is to the western sides. And then since a reference has been made way to Kiritis house, there is a road, and all post office reference is also made because they tried to show and project why I have referred to this all post office. They have tried to project on several occasions that the disputed land is not the same one. It is different one. That is what they have been making submission and making a lot of attempts. And opposite to post office, in front of the post office. So it is both correct. It is opposite, and it is also in front of the old post office. So this is the area.
Now,
So-
what, according to appellant, where your land, where this according to you, this is your land.
Correct, Lordship.
According to appellant, they are saying you have some other land.
During the
Where it
course
is
of,
situated?
during the course of my submission, I will come to that. On several occasions, they tried to create some twist and then show that, no, this is not the land, this is something else. But the fact remains that the present appellant himself has admitted during the deposition, during the cross-examination before the PAC, the latest trial. There he has admitted that, yes, I have constructed the suit building in the suit land. So he himself has admitted, and before this honorable court, on the earlier occasion, in early 90s, the counsel for the present appellant, one Charukubal Singh, he is from Manipur, an advocate from Manipur. He has made the same submission that, no, this is not the location. I will come to the appropriate stage. And that. So this is the suit plan. According to them, I do not know. And incidentally and interestingly, during this proceeding, in this proceeding, unless I have not heard properly, I have not heard they are making any submission at this point. Documents are there, but they have not advanced any argument on this point. That no, the land is different. They have not advanced that argument in this proceeding. But
No,
I will show
Mr.
from the
Hiralu
report.
has made submission on last occasion.
I'll show from record.
Okay.
They have been making that submission. Now, the area of land, Sanu's land and Kiriti's land, the Sud land, all this area above the road. The police point itself is located and the road showing towards the down is in such an area that it is a saddle, Lordship. Both,
No, make it clear. What is above the road and this?
that
way?
is why, saddle. Beyond this
In this
road,
map, in
on the
this-
left, yes, on the left-hand side, where Kiriti's land, Sanu's land is shown, Sud land is shown.
Towards east.
This is, yes, towards the east. It goes up, elevated.
When we are saying above the road, which road we are
Yes,
referring?
that's why
This town road,
I'm coming, yes. Above the road means down road,
town road.
above the road.
Okay.
And again, on the opposite side, old post office, new building, SBI building, way to Kichiri's house. This is also above the road.
This is also above the road.
That's why it is in a place, a saddle. Both sides, it goes up. And the down road is in the middle. So, in other words, I'm saying it is a saddle. Both sides are uphill and the middle of the road is little down like a river. So the area is located in such a place. And this eastern side,
No, one more query.
Lordship,
Which area we refer to as area down the road? Which area in this map? Where?
down the road,
Down the road. Because the submission of learned council for the
Yes.
appellant was,
Yes.
there were two clans.
yes,
One clan is having above the road and one clan is having down the road.
yes.
And Kiriti belonged to a particular clan. That was
Veros
also
clan.
their submission.
We belong to a clan who were owning the entire land on the eastern side.
Eastern side.
Beyond this way to Chikri Nisa colony, beyond this towards the north. And by the side of the road are all land held by the Vero clan of Kikroma village. Now, below the road will be,
Which area is below the road?
below the road should be up to the police point. The word police point is shown. This is below the road
Okay, that north.
because road is up to the road, it goes down, receding.
Okay.
But so far as the down road is concerned, both
That
sides are
north
uphill.
area remains below the road.
Yes,
Area shown in north remains below the road.
yes,
And area shown in east and south is above the road. Where
both are above.
both are above.
Yes,
So Suitland is also situated above the road.
yes,
Road you are referring Kohima Fake Road.
yes. And down road, the disputed Sud land is in the down road. Now, this entire land towards the east have been owned by the Kiro clan of Kikroma village, Vero clan of Kikroma village. And Tachuni and Vichune and Kiriti are all belong to Vero clan.
Vero clan, yes.
Yes, they all belong to the same clan. And the earlier, the Sanukizo's land. Here in this place, including the Sud land, there was a garment dispensary constructed by Health and Family Welfare Department. Because the
Covering the Suitland also. Covering the Suitland also.
Yes, yes, exactly. May not have been the building, but in this area, there was a dispensary.
Okay.
And then this dispensary, they have abandoned in way back in 1972. After that, the clan members started acquiring and claiming the land. It so happened that whoever can occupy first, it turned to be their owner because it was occupied by the government at one point of time. In 1972, government dispensary has vacated and they have shifted elsewhere. Therefore, the original landowners who are Vero clan from Kikruma village, they started claiming the land. And the Tachuni and Bichuni, who belong to the same clan, they have been occupying this Hanyu Kizo's land. Earlier,
Not this woodland.
they have occupied this portion.
Okay.
And Vichone and the Chuni, they have sold this land to one Piri Chibi Kangpura.
Yes.
Piri Chibi,
Which land? The land which you have shown as
where
Senuk is
Sanu Kizo's land is shown.
shown.
This has been sold by
Pire,
the Chuni and Vichone to
Pire.
Piri Chibi.
Okay.
Till that time, there was no dispute. Now,
This sale was in year 1969
no,
as claimed
cannot
by-
be, cannot be. In any case, it should be up to 1972. Otherwise, they will be young and energetic even now. They will not be existing.
But is it
Prior
is
to-
your claim now that
Prior-
that has been purchased in 1969?
Yes,
The document which you want to now bring in as additional document?
yes.
Okay, okay.
That will automatically die.
Now, okay. Just I want to make myself clear.
Now, BDGB sold the land to Hutsutsu.
Okay.
Hutsutsu. The same land where Sanyu Kizo's land is
Which
shown
he
here.
purchased from Dachoni and
Exactly,
Vichoni.
exactly. The Chunin Vichune to BDGB,
Pire and Hutsozo.
BDGB to Hutsutsu.
Okay,
Yes. And the land is 24/12. And they are not disputing that. The
This
area
land?
of the land.
this land,
Yes. No. This is a bigger one. But the suit land is 12/24.
so the land, now one query, Mr. Zamir.
Lordship.
The land which was sold by Pire GB to Hutsozo,
Yes.
whether that included this suit land 24/10
No.
or excluding it?
That is a relevant question. Suit land do not include. But what happened? After Hutsutsu purchased from PDGB, he started claiming this suit land.
Who?
Hutsutsu,
Hutsozo.
although he has purchased only the present Sanu Kizo's land.
Okay,
But since the land is adjacent to Sanu Kizo, Hutsutsu has started claiming this portion of land.
understood. Therefore, a dispute between Kiriti and Hutsozo,
Yes,
and therefore that 75 compromise.
exactly, Lord.
Okay,
That is very clear. Trouble started to substantiate that. Trouble started from Hutsutsu. So dispute started from there. Therefore, Kiriti has filed a complaint against Hutsutsu.
okay.
That's how Lordship, what has Lordship has said, I need not elaborate on that. And
Now you
Hutsutsu,
elaborate everything. It will help me.
because Lordship is clear
In
On that
75,
point.
complaint was filed
by Kiriti.
Kerete against Hutsozo.
Yes, because although he has purchased the adjacent land, the land which he has purchased do not include the suit land, but then Hutsutsu started claiming the land. That's how Kiriti has filed a case. It was heard by the PA to DC, Sakitsa, and decided in favor of Kiriti. That verdict was also accepted by Hutsutsu. Thereafter, the taking up earth by Kiriti started. They were also mentioning about taking up earth, but actually the taking up earth is by Kiriti Bureau started. Sanyo Kizo purchased from Hutsutsu,
The land,
the present,
the adjacent land.
yes. No, here Lordship will see that Sanyo Kizo's land. this
That
was
he purchased
purchased.
from Hutsozo.
Yes, Hutsuto. And immediately after purchase, he has also accepted the present possession also for some time. Kiriti was taking the earth in the suit land, in his own land, but Sanyo Kizo did not have any objection during that time.
Okay.
So another theory will come now. When the situation was like that, one Ane Viro also comes to picture,
Yes.
and one Punguru also comes to picture. Ane Viro is the younger brother of Pichune and Dachune.
Yes.
And it so happened that he purchased the land from Punguru.
Pungro is your brother.
Yes, my brother. And
Ane
Ane has-
purchased which land?
I don't know which land he has purchased, but Ane has claimed that, look, you have sold Kiriti's land without Kiriti's permission. That is how record shows. Therefore, that is also compromised and accepted by all.
That is in the year 76, 79.
Yes, Lordship.
No, 76.
76,
Ane versus
Punguru.
Pungro. There was some other name.
Ane versus
The second case. Where Mr. A. Dogra passed the,
but this is on the case filed by Ane
against
against the Punguru.
Kutsoyo.
Hutsuto.
Kutsozo.
Hutsuyo.
Yes.
Now, that is a brief background, how the land has been transferred from one another, and then that I'm not referring to 1975 settlement where compromise was made. They have referred to this document.
Till this time, the land, the suit land 12/24 was in whose possession? Who was possessing?
Heritage possession, obviously.
You are possessing.
Yes, Sanyo came in the picture sometime in 1984-85.
Okay.
Prior to that, he was nowhere. And he is claiming that, look, in 1969, I have purchased, and then I do not know where there was a dispute. He has acted that I do not know about the case, which is adjacent to his land. That is what he tried to claim. And the fact remains that till 1972, the suit land was under the occupation of the government because one dispensary was there. And up to 1972, only these landowners, original landowners, who are the Viro clan of Kikrama village, have started acquiring the lands. It is a clan land, so all clan members has got the rights.
Yes.
Since my learned friend has not referred to the judgment of the ADC J. Kohima, I would like to refer to that, page 69, Lordship. Because this is relevant so as to show how the case has been heard. And from here, we can get a lot of facts which were not in the other records also. And then by reading this, I will also show some relevant queries which Lordship may like to put. And here, the case is referred as Civil Revision 1 of 2001.
This case was, this judgment was delivered on 28/11/2005,
Correct, Lordship.
when judiciary was not separated.
Yes. And Lordship will find the nomenclature was not changed
Changed.
that time. And Lordship will find on the top, Civil Revision number 1 of 2001, on the extreme right on the top.
Yes.
So for a moment, Lordship may come to page 151, because there was some confusion by my learned friend about the numbering of the case. Why this civil revision, all these things, and there was a query from this honorable court also. Order by 2005. Judicial, change. 151, Lordship.
Yes, what is this?
This is to show the case number, Lordship. Civil Revision 1 of
This is the
2001.
impugned judgment
Yes,
in this appeal.
yes. And the number is same, because this honorable court, by judgment and order dated 10/7/2017, has directed the lower courts, that is District Judge Peck, to rehear the matter of this case, and the case number is shown as Civil Revision number 1 of 2001. Page 151 and page 69, annexure F will make it very clear, Lordship.
Yes.
Am I clear, Lordship? Yes. So although it is still daring, but I may be allowed to read this judgment, because it will reveal a lot of facts, Lordship. Whatever is relevant and necessary for us, we can take out. Whatever is not relevant, we can leave it. It's judgment dated 28/11/2005. May I read, Lordship? The present case was tried till the stage of evidence and transferred by an order of the Law Department, White Order number so-and-so, dated 2nd June 2004, setting allegations and counter-allegations by the parties. Argument was heard by this court, and inordinate delay was caused in pronouncing the judgment, as the case is voluminous, pertaining to 30 years of legal battle in several courts. Facts of the case is best presented by clarity. The present dispute is over a piece of plot commercial measuring 12 feet by 24 feet, which located in the heart of Putsuro Down. Shri Kiriti Viro, plaintiff. Here plaintiff, defendant, respondent, petitioner, all these are interchangeably used, but here Kiriti Viro, plaintiff, belongs to Viro Kel of Kekruma village in Fik district. Kiriti Viro had owned landed property with Sri Tachuni Viro and Vichuni Viro, Chakranesa colony in Putsuro Down. Tachuni Viro and Vichuni Viro sold their share of property to Hutsotso. A dispute arose between Kiriti Viro and Hutsotso with respect to the boundary of the land. The dispute was settled by the PA to DC, who compromised the dispute between Kiriti Viro and Hutsotso. The small portion opposite to the post office on the front went in favor of Kiriti Viro. So this is the present disputed land, Lordship. Thereafter, Any Viro, younger brother of Tachuni and Vichuni Viro, filed a suit before Shri A. Tokra, JMSC Putsuro, stating in Ralia that he has purchased the suit land from older brother of Kiriti Viro, Shri Punguro Viro, to return a sum of rupees 1,200 to Aneviro for selling the land of Kiriti without his consent. Decision of Shri So-and-so PADTC was upheld. This was decided under CS number 27 of 76. Ani again with one Mutsatso filed an appeal before the SDO Civil Putsuro, and then dates are shown 3/4/1979. Shri A. Dokra, JMSC Putsuro, held that Ani and Mutsatso have no right over the disputed land and kept Hedel do Kiriti. So two strangers were fighting, and then the land was given to Kiriti. 6/4/84. The Chune Viro and Vichune Viro filed a petition before SDO Civil Putsuro against the order of A. Dokra JMSC, challenging his order dated 27/9/77 and 3/4/79. This appeal was dismissed by Shri N.H. Nakro, SDO Civil Putsuro, on 12/6/1984. The Chune Viro and Vichuni preferred an appeal against this order before Shri H. Hang Singh, the then ADC and ADM, that is Additional District Magistrate, the exercise congruent powers. 13/11/1984. Shri H. Hang Singh, ADC and ADM returned the case to SDO Civil Putsuro and for retrial of the case, and directed that no party should develop the suit led till the case is settled. 13/3/1985. Shri N.H. Nakru rejected the appeal filed by the Chuni and Vichuni and appealed the decision passed by EAC Putsuro. At this stage, respondents Shri Sanyu Kizo filed an appeal before H. Hang Singh ADC and ADM PAC dated 13/3/1985, passed by the SDO Civil Putsuro. The appeal was registered as CA 48 of 85. 31/1/1986. ADM PAC declared that Sanyo Kizo was the absolute owner of the plot of land, and the order dated 13/3/1985 was declared null and void. The same plot is under dispute till date. Shri Kiriti Vero, plaintiff, was not given notice in the said proceeding, and the order dated 13/1/1986 was passed behind the back of Kiriti Vero. Aggrieved by this order of ADM, Shri Kiriti Vero filed a civil revision in the Gauhati High Court, numbered Civil Revision 10H of 1986. All throughout the proceeding, Sanyo Kezo has succeeded only once, that too an ex parte order, without hearing Kiriti Vero. So he has filed the appeal before the writ petition before the High Court. 22/6/1990. The High Court quashed the order dated 31/1/1986 passed by H. Hang Singh, proceeding from the stage of examination of witnesses and quashed. The petition was allowed and disposed of with directions to lower court ATM PAC after giving opportunity to all the parties. 30/10/1990. L.N. Sima, ADCJ PAC, passed an order directing Kiriti Vero to file a plaint against Tachuni Vero, Vichuni Vero, and Sanyo Kizo, stating facts and reliefs claim. Aggrieved by this order, Kiriti Vero filed a revision petition in the Gauhati High Court on the ground that no cause of action arose for Kiriti to file a suit against Sanyo Kizo. This was registered as Civil Revision 2K of 1991. This is also important because the lower court has directed Kiriti Vero to file a suit. So I cannot file a case against me. So there is no cause of action. So there is no question of filing a case. That is how I have approached the Kiriti Vero has approached the High Court. 3/12/1991. The Honorable High Court set aside the ambient order dated 28/11/1990, passed by the ADCJ PAC, and Sanyo Kizo was given the liberty to sue anyone he felt deemed fit. In violation of the High Court's order, Sanyo Kizo started construction in the suit land without filing a plaint. Aggrieved by this illegal construction of Sanyo Kizo in the suit land, Kiriti filed a revision, Civil Revision 13K of 1992 in the Gauhati High Court. Another case was filed, CR number 104K of 1992, was filed by Kiriti Vero for misuse of official power, as Sanyu Kizu was the officer in charge of Utsuro Police Station. Lordship is well aware, my learned friend has also referred to about these two cases. So these two cases is what is a writ petition, seeking a direction to the government to take action against the present appellant. And another case is against the order passed by the lower court. 27/8/1992. Sanyu Kizo filed an application before ADC Hague for disposal of CS 48 of 1985. This application was treated as a plain by the High Court. So here goes the drama, Lordship. This application, that is CS 48 of 1985, this application was treated as a plain by the High Court. However, records show that it is a miscellaneous application for disposal of CS 48 of 85. So Lordship will find in the same page, 13/3/1985, up just above, in the top of the page, in the second paragraph, Lordship will find 13/3/1985. Shri Nakro rejected an appeal filed by Dachuni and Bichuni Bureau and appealed the decision passed by ESA Butsuro. At this stage, respondent Shri Sanyu Kizo filed an appeal before H. Hangsing, ADC and ADM Hague dated 13/3/85, passed by the STO Civil. The appeal was registered as CA 48 of 85. So this was for early disposal of the case. This 48 of 85 filed by Sanyu. But this honorable court has treated this as a plain. So that's how the mistake also.
Now, whether the application which was filed on 13/3/85
Yes,
by Sanyo Kizo,
yes,
it was filed for expeditious disposal of the case.
Lordship.
Whether same is referred at in against the date 27/8/92, where High Court said that treat that application as plain.
Yes. So if it is to be treated as a plain, then Sanyu should have been treated as the plaintiff.
Now, what is
Now,
this-
next-
what this line
Next
means?
page, Lordship.
No, before we go to next page.
I think next page will clarify this.
Now, however, record shows that it is a miscellaneous application.
For disposal of CS 45 of 85. The case which was pending before ADC JPEG is CS 48 of 85. This application is an application
But
filed for,
against date 13/3/85,
yes,
it mentions about an appeal registered as CA 48/85.
yes,
Appeal registered at CA 45/85.
yes.
Against 27/8/92, it mentions about miscellaneous application for disposal of CS.
Lordship, yes, this should be CS.
Is it CS or
Sometimes
CA?
they have used CA, sometimes they have used CS. We were not sure whether it is a suit. It
Or
is
an appeal.
Yes. So interchangeability, it was used. Now
Okay.
kindly come to the next page, page 71. 29/6/1993.
Yes.
29/6/1993, High Court allowed CR number 12K of 92 and CR number 104K of 92 and imposed a fine of rupees 200 as cost of Sanyu Kizo. I think it should be 2. Direction was also given that the petition filed on 27/8/1992 be treated as a plaint and to dispose of the same within 8 months. Sanyu Kizo filed civil revision number 8K of 1993 and sought review of the order dated 29/6/1994. This order has already been referred to my learned friend, but again, here also it is mentioned, 10/1/1994. Review petition was rejected and direction was given to lower court, that is ADC JPEG, to dispose of the suit within 8 months beginning from 1/2/1994, now 2001. Instead of taking steps as per court order, Sanyo Kizo started further construction in the disputed land. 27/6/2001. Kiriti Vero lodged a complaint to ADC Pochoro against Sanyo Kizo and prayed to suspend the work done by Sanyo Kizo. 29/6/2001. ADC JPEG MK Mero granted temporary injunction. 23/8/2001. Sanyo Kizo filed an application, CR number 1 of 2001, before ADC JPEG for vacation of the injunction order. 28/8/2001. Kiriti Vero reported the matter of further construction by Sanyo Kizo with a prayer to take necessary action. 30/8/2001. ADC Pochoro transmitted the complaint to ADC JPEG. 12/9/2001. Sanyo Kizo filed another petition for vacation of injunction. 5/12/2002. ADC JPEG rejected the application for vacation. This is also a very important order. 11/6/2002. ADC JPEG passed an order that CS 48/85 was not traceable. Parties agreed to file respective brief stories of the case and file issues. This will be important, Lordship. CS 48/85 was not traceable, so parties have agreed to file respective brief stories of the case and file issues. And then on 9/7/2003, parties filed brief stories and suggested issues. Issues framed on the basis of statements and documents filed by the respective parties. This will also answer to the submission of my learned friend that no written statement was filed. How that can be done? So this is very clear. Parties have agreed because original records are not there. Therefore, parties were given liberty to file their respective statements, and on the basis of that, the issues were framed and the case was decided. This is the record. I'm not just saying from the air. 12/8/2003 to 13/1/2004. Evidence of parties taken and examined with the witnesses. 23/8/2004. Case records received by this court, which was transmitted by an order of the law department, White so-and-so, dated 2nd June 2004, citing allegations and counter allegations by the parties. So because of some problem, the case was transferred to Kohima. And then it was forwarded through law department and the court has received. Case was refixed on 3 occasions till 18/10/2004 on the request of the parties, and argument heard on 28th of October, that is 28/10/2004. Having laid out the facts and the different decisions undergone in different courts, let us now examine the issues proposed for the decision of the long pending case by the parties. The parties have brought 3 witnesses each to prove their case. It is also to be kept in mind that the direction of the Honorable High Court was to try the matter de novo, not spelling out the term clearly. Reference is made to Civil Revision number 13K of 1992 and Civil Rule 104K of 192. The suit, therefore, does not take the nature of a revision petition, but a fresh suit to establish whether the plaint submitted by the petitioner, that is Sanyo Kizo, can stand the scrutiny of law to keep title over the land in question under the given circumstances and facts, as he was never a party to suit beginning from 19/6/1975 to till 1985. So this is an admitted position that he was not in picture, the appellant, till 1985. The issues are 1, whether the present suit is maintainable against. I think I need not read these issues.
Because this is
let
same
me-
what Mr. Iralu read.
Yes. So the last paragraph. This issue would have been best settled at the preliminary stage. In my considered view, the suit is maintainable a dispute over the right of a plot exists between Kiriti Biro and Senyo Kizo. Honorable High Court has also given liberty to Senyo Kizo in Civil Rule number 2K of 92 to sue anyone against whom he desires as having legal right. 2. Whether there is non-joinder of or misjoinder of suit. This is also an issue best settled at the preliminary stage. It will be erroneous thing to rewind the clock after having put such a voluminous effort. As discussed in the introduction, the present case almost takes the nature of a fresh suit, given the fact and keeping in mind the direction given by the Honorable High Court to treat the petition filed before Additional Deputy Commissioner Judicial, Mr. Sanyu has rightly proposed to agitate his case against the present respondent, plaintiff Kiriti Vero. The suit does not suffer from non-jointer or misjoinder. 3. Whether the disputed plot of land was actually sold to the present respondent petitioner, that is Sanyo Kizo, because the parties have been used respondent petitioner, appellant, plaintiff, defendant. That's why they have made it very clear. If so, why was not implicated as a party in the proceeding? Scrutiny of the records shows that there was no dispute between Sanyo Kizo and Kiriti Vero before 1985. This is also very important. And now they want to introduce a document which is of 1969.
Yes.
Scrutiny of records shows that, yes, that is already the cell number 1. The only dispute as recorded are between Hotsotso and Kiriti Vero in 1975, Ani Vero versus Kiriti 1975, Ani Vero Mochacho versus Kiriti 1979, Tachuni Vero and Vichuni Vero versus Kiriti 1984. There is no mention whatsoever of Sanyo Kizo or GB Piri by Tachuni, Vichuni, or Ane, who are supposedly the land owners. It was only a discovery of after 10 years of litigation, a new development not made known to the civil courts or the administration by the original land owners. Under the circumstances, how was the present plaintiff respondent Kiriti to file a suit against Mr. Sanyo Kizo? There was not even a whisper of the name of the present petitioner, that is Sanyo Kizo, from the land owners whatsoever in the long 10 years of acrimonious legal battle. GB Piri and Sanyo are both people involved in the administrative works, and to claim that the fact of the legal battle of 10 years went unnoticed to them over a plot immediately adjacent to Sanyo Kizo's building is a proposition extremely hard to concede to. This is very important because he is claiming that I did not know there was a dispute adjacent to my land. And there was a legal battle for the last long 10 years. The law gives notice to people who are alert to one's right and not someone who slips over his rights. In the instant case, the civil courts to apply law of adverse possession is just short by 2 years only. Given these facts, it is ruled that non-implementment of the present petitioner by the plaintiff respondent has not adversely affected of his case. However, for our present purpose, we are to remember that the High Court's direction to consider the petition of the respondent petitioner as a plain and to follow necessary procedures has mitigated the cruciality of this issue on the decision of the case at hand, and it needs no further elaboration and discussion. The issue, whether the disputed plot was sold to petitioner, is an issue which attracts the curiosity of the court. If so, when? The rulings of the different courts have appealed the decision in favor of the plaintiff beginning 1975 till 1985. The claim of the petitioner is based on the statement of G.B. Perry's son, Mr. Satahu Tune, who has been examined as PW2, who states that he is aware of a plot of land being sold to Sanyu, but he is aware of its details. He does not know the details of the plot of its area for how much it was sold, as he was 10 years only. Then we have another witness, Chuni, who is the original landowner with the Chuni and Ane. His statement is clear that it has been sold to the present petitioner. It is now therefore a question of evidence. There are several refuting evidences against the claim of the petitioner. This remains the crux of the case. Next page is page 74. The rulings of different civil courts have given the title to the present respondent plaintiff. Number 2, there is evidence of land being sold by Tachuni and Vichuni to Kiriti Bureau contained in Exhibit A at page 85 and 86. The difficulty of any court is to give credence to a sale when the landowner sell to two purchasers. Tachuni is no more. Only the documents he left behind bears testimony to the sale. Whether the court is to rely on the documents given by a co-owner who is no more, or to give credence to a living witness. In such circumstances, the court, as a rule of prudence, cling to the maxim, men may lie, but documents cannot lie. Any given court will rely on the documents at hand, which has not been questioned. The records in the exhibit states clearly that the small plot empty belongs to Kiriti Bureau. Where has this plot gone? I am confident that the deceased has given testimony of the plot in question. The sale does not therefore enclose the present disputed area, but only speaks of the sale made to Hochocho, which remains distinct one from the present disputed plot. There cannot be a clear case for a petitioner when the seller himself is confused. Exhibit B at page 87 and 88 also speaks of the land being sold to Kiriti Bureau for rupees 2,600. It describes of a plot between Sanyu and Pisuru for which Kiriti has paid a consideration of rupees 2,600, though Mr. Vingoyo, the son of Ane, who is the joint owner of the land in question. Punguro, the brother of Kiriti, exhibits a negative case against the plaintiff respondent by stating that he have no claim above the road as it belongs to Kutsurumi clan. The proposition is agreed by the plaintiff himself. Let us examine the order of Shri Tokra JMSC, where the civil court has imposed a fine of fine on Shri Punguru, a sum of rupees 500, for illegally selling the land of Kiriti without his consent. One serious question is, why did Punguru sell a land which he claims his clan does not have a right on? Must Punguru state one thing and do another? The credibility of this witness is doubted. We cannot accept this declaration as a truthful one. So the trial court has negated what he has stated. The only civil court which has shown favor to the present petitioner is the Court of Additional District Magistrate A. Changsing, which has been quashed by the Honorable High Court Gauhati under Civil Revision number 10 H of 86 and is of no legal consequence. It was rightly, because it was an ex parte order, rightly quashed for violation of the principles of auti alteram partem. It cannot be doubted that under the circumstances that one may conclude that the claim of purchase is a manufactured one. If at all sale was there, Fechuni alone could have made the sale only after 1985, not before, as revealed by the documents placed before this court for scrutiny. So court has examined all the documents. The sale of the land documents, sale of the land does not have the endorsement of other landowners except the Chuni. The data purchase is doubtful with records put together. 4. Whether the plaintiff respondent filed a case against Piri Chibi, Tachuni, and Vichuni prior to 1969. So this issue raised the petitioner is a self-defeating issue as it proves that Mr. Sanyu was never in possession of the suit land. Had this been so, Mr. Kiriti would have filed a suit against Mr. Sanyu. Documents reveals that the land was in occupation of the government till 1972. Buying up land in 1969 is a remote possibility. This is very important. And this finding, of course, this has been subsequently.
Ultimately, this judgment was set aside.
Yes. Now, 5. Whether the present respondent petitioner was disturbed. The petitioner was disturbed by the respondent plaintiff by obtaining order from civil court. When the respondent remains a plaintiff, questioning the disturbances through motion of proceedings of law cannot be termed as wrongful disturbance. 6. Why plaintiff respondent had not initiated action when the disputed plot remains in possession of the respondent petitioner after having purchased from GB Piri. Facts and documents do not speak of the possession by the petitioner. Notice of the Vice Chairman, Potsuro Town Committee shows at Annexure O at page 137 here's testimony of the possession of the suit land by the plaintiff. They claim that the suit land was in possession of the petitioner since 1969. Totally erroneous. Government vacated the land only in 1972. I think other proceedings are almost a repetition. Kindly come to page 76. The operative portion, I'm reading from the second paragraph. From all the above foregoing discussions, the court finds the issue raised all go in favor of Kiriti Viro, the plaintiff respondent. The sale purchase of 1969 from Tachuni and Vichuni by the petitioner has discrepancies and no documentary support. Vichuni, one of the original owners of the land in question, who survives Tachuni, is not a trustworthy witness himself. Documents rendered by Tachuni in his lifetime negates his fallacious statements. Non-prosecution of his rights by the petitioner for long 10 years, which was in litigation over a plot just adjacent to his building, seriously jeopardized any testimony of the purchase of 1969. No mention of the same was ever made even by Tachuni or Vichuni in the previous proceedings over the same plot till 1985. When the present petitioner is introduced to the dispute, purchase of the land may have taken place, but the date is distorted. The law also does not permit resale of the same plot to a different person. Vichuni must bear all its consequences and the order. This is in the form of a decree. The scrutiny of all the documents and records reveal that the plaintiff respondent, Shri Kiriti Vero, has the valid legal claim over the land in dispute. This court hereby declares the title of the land in dispute measuring 24/12 at Potsuro Town in favor of Kiriti Vero. Construction of building in the land in dispute has the preemptive order of the Honorable High Court in the Civil Revision number 13K of 92 and Civil Revision number 104K of 92. Parties to abide by the same order on the outcome of the petition. With this judgment and order present, civil suit is disposed of here. Herewith, case records be transmitted to Learned JPEG for further post litigations. So this order has been challenged by the present appellant we are filing a first appeal under caption first appeal number 1K of 2006. Lordship will find at page 71. 77, sorry.
Yes.
Others are just a formality. Let me switch over to the next page. Operative portion starts from paragraph 3. Page 78. May I read, Lordship?
This appeal was before
This is before the Honorable Court.
this court.
Yes. And the file under Rule 29 of the Rules for Administration. Paragraph 3, Lordship. The effects and circumstances which led to the filing of the present appeal are briefly stated here below for proper appreciation and understanding of the dispute between the parties. In the year 1975, a dispute arose between Shri Kiriti Vero, the respondent in this appeal, and one Shri Hututu regarding ownership of the suit land. The dispute reached the office of the political assistant to the Deputy Commissioner Zakitsa. The parties resolved the dispute through a compromise settlement before the political assistant to the Deputy Commissioner Zakitsa, and the land in dispute was given to Shri Kiriti Vero, the respondent. Thereafter, one Shri Ani, younger brother of the Chuni and Bichuni, filed a civil suit before the judicial magistrate second class Pochuru, stating that the suit land belongs to him as he had purchased the same from Shri Punguru, elder brother of Kiriti Vero. The same was registered as civil suit number 27 of 76. The judicial magistrate second class Pochuru on 27/9/77 disposed the same by holding that Kiriti Vero is the owner of the land and imposed a fine of rupees 500 on Shri Punguru for selling the land of his brother, which did not belong to him. He was further directed to return a sum of rupees 1,200 to Shri Ani. Thereafter, Shri Muchachu approached the SDO Civil Pochuru on appeal, claiming the ownership of the suit land. The appeal was registered as number so-and-so, and the same was disposed of by Judicial Magistrate second class Pochuru on 3/4/1979, dismissing the claim. In 1984, Shri Tachuni and Bichuni Vero filed an application before the SDO Civil Pochuru challenging Shri Kiriti's ownership of the suit land. The same was registered as number so-and-so, 84/82, and SDO Civil disposed of the matter on 12/6/84, rejecting the claim of Shri Tachuni and Bichuni Vero on the ground that the matter has been settled 4 to 5 years ago. Therefore, it cannot go longer be reopened. Against this order of the SDO Civil Pochuru, Shri Tachuni and Bichuni had appealed before the ADCJ. These are all, I think,
Narration of fact.
narration
there is
of
not-
facts.
Is there any discrepancy between what has been narrated by ADC Kohima in his judgment and by the High Court? There is no,
Kindly come to page 82. This is the I will just refer to the relevant ones. After the judgment and order of this court given above was received by the ADC JPEG, the parties appeared before the court. Has your lordship got it?
yes, page 82.
Yes. However, it appears from the order dated 9/7/2003 of the learned ADC JPEG that the entire records of the case number 48 of 1985 was untraceable. Therefore, both the learned counsels representing the parties filed the brief stories of the respective case along with suggested issues. Based on those brief stories, this is important, and suggested issues, the learned ADC JPEG framed 13 issues, and thereafter, the parties produced their respective witnesses and their depositions were recorded. So this paragraph 5, the upper portion will be relevant because they have made a claim that no written statement was filed. All these points they have raised. But the fact remains, trial was conducted on the basis of the records available with the court, and the parties were directed to file in the earlier proceeding to file suit, because this is a continuation of the earlier proceeding, not a fresh proceeding. And the issues are there just below that. I'll skip that. And then this is a reproduction. The next page, page 83, what order was passed. And then the grounds which were taken in the appeal has been produced under paragraph 7. And last 3 pages I may be allowed to read, Lordship. Page 86, paragraph 8. As your Lordship carry. Page 86, paragraph 8. Mr. C.T. Jamir, Learned General Counsel for the respondent submitted as follows. 1. That the court has to examine the whole records and to pick here and there, or should not be influenced by minor discrepancies in deciding the dispute. Because there are so many points. Out of 10, it's in my favor. 1 is against me. Just you picked up that since it is against me, and then use that and then defeat the entire 10 merit points. That will not be proper. And in that context, I was making this submission also. 2, that since the record was lost, the parties were asked to submit a brief history of their respective case, and accordingly, the respondent submitted the same, and it was treated as written statement. Therefore, it would be wrong to say that the respondent did not submit written statement. The Learned Counsel also submitted that based on such submissions, issues were framed and the trial proceeded. Therefore, the submission of Learned Counsel of the appellant that no written statement was submitted as such, the issues framed by the trial court should not have been framed is not based on facts. The same submission which my learned friend has made yesterday, same submission was also made on the earlier occasion. But
Now you are making again same submission. You are sticking to same submission.
no, this is about the last proceeding. I'm reading out.
But your stand remains same.
The trial court relied on the documents which were exhibited in records as, and then to whom it may concern, that those are the points which I have relied, 1 to 5. These are the points which I have relied upon. Now, paragraph 9. This is the finding of the Honorable Court. I have considered both the case of the appellant and the respondent are submitted by their counsels. I have also gone through the evidences given by the witnesses and the entire records of the learned Additional Deputy Commissioner Kohima. It appears from the statements given by the witnesses that neither the nor the parties in dispute were aware of the fact that to prove their respective case, they have to exhibit all the documents on which their claims are based upon and to prove the same too. Further, from the submissions of both the learned counsels, also it appears that there was a misconception on the part of the parties regarding the way how secondary evidence is to be produced and proved to give the same evidential value. The ambiguous judgment and order of the trial court also shows that the learned ADCJ Kohima was of the understanding that it is sufficient if a document is filed and exhibited. When the parties are equally well entrenched against each other, the respondents as well as the it doesn't make any difference or be documents if any evidence is exhibited and proved. In this case, as stated above, the appellant in the deposition stated that he had a sale deed agreement and he can produce it as and when necessary. Likewise, the case of the respondent also, he seems to have depended upon documents which were not even exhibited. Lordship, here, in this case, the first 2 lines in the second paragraph, in this case, as stated above, the appellant, this is the present appellant, in his deposition stated that he had a sale deed agreement and he can produce it as and when necessary. This was a submission made before this honorable court. When the trial conducted before the district judge Peg, I will produce that because I have a sale deed. They have not exhibited that, they have not produced that. Only now, during the pendency of this present appeal, they have filed an application under Order 41, Rule 27, by enclosing this document of sale date of 1961. And very interestingly, the grounds taken in this application under Order 41, Rule 27 was, although I had, it was misplaced and it was not received. But when the order was passed and matter was heard before the Honorable Court way back in 2017, they have made a categorical statement that yes, I have a sale deed, I will produce as and when the trial is comes. And trial was conducted by the district judge Peck. During that time also, they have not furnished that sale deed. And now they are complaining, coming with a plea. How many times? It will be rounding again and again. There will be no end. That is what they are playing now. What prevented them to enclose that document while adducing the evidence before the learned court below, before the DC Peck?
But this time they have produced the original one here.
Whether it is original or not,
That is the
whether that
question.
is legally permissible or not at this stage, that will be
Is to be
considered by the Honorable Court. A great high level of restraint is to be made. And even if it is allowed, with justifiable reason only, that can be allowed. Otherwise, not. So by going through the application, what was the reason? What were the statements they have made before the court? All this has to be taken into consideration. Lordship, let me continue the third paragraph. The paragraph starts with, in view of what? This is the finding of this Honorable Court. Mr. Lordship, got it?
Yes.
In view of what has been said above, I'm of the view that to do full justice, the parties must be given a chance of proving their respective case properly. I'm aware that this dispute has dragged on for a long time, but it would be better if both the parties and for the ends of justice to have the case tried properly as per law, so that the litigants finally come to an end, litigation come to an end. Therefore, this is the reason, Lordship. Therefore, the impugned judgment and order is set aside, and the district judge Peck is directed to try the case afresh by giving the parties a chance to exhibit and prove all the documents on which they want to rely on for their respective case. To do that, further examination of witnesses already examined may be required, and if so, the witnesses already examined may be allowed to give further evidence in respect of the documents. Now, in terms of this direction passed by this Honorable Court, the trial court Peck, that is the district judge Peck, has conducted the trial strictly in terms of the directions given by this Honorable Court, and what was to be done, what is required to be done, everything has been mentioned in this order. This Honorable Court has given a clear direction that in what manner the trial is to be conducted, and the parties should be given full opportunity to examine and cross-examine the witnesses. It's not that they were not given opportunity of being heard. If that be so, let them come with a ground. Although I wanted to exhibit some documents, the learned court below has denied to exhibit that. Although I wanted to say something else, very important, learned trial court has denied me. Has the appellant taken that ground in this appeal, present appeal? Because they are challenging that order passed by the district judge. If that is the ground, yes, there may be a point to consider. They have got the full opportunity to examine and to cross-examine, to exhibit any document. And they can also debate any document if something is placed before the court, which is not in accordance with law. They got the full opportunity Is it your case that learned trial court has not proceeded the trial in terms of the direction passed by this honorable court? Is it the case? Absolutely not. Not even a whisper in the grounds. Therefore, just because by trying to find some faults, they want to ignore the trial. It is a painstaking trial. Parties are suffering. And with the huge efforts have been given by the trial court to conduct a trial. And they have got the full opportunity. Therefore, there is no ground for them to agitate before this appellate court when they got the full opportunity before the trial court, which is the court who can examine all the documents. Anything can be exhibited. Trial court has the opportunity to examine all the documents relied by different parties and the statements, witnesses. It's not only the parties that they can examine and cross-examine. Even the court has the duty and court has done that. And after examining all this, after considering all this, the judgment has been passed. Where the learned court has gone wrong. Whatever points they have raised, these are all the points which is not permissible in the IAP. These documents could not happen considered by the trial court. You got the opportunity to raise objection there. Why you have not raised? It's not their case. I'm repeating it, a course of repetition I'm submitting. It's not their case that in spite of our persuasion, in spite of our request, in spite of our appeal, the learned trial court has denied us to do this. Nowhere in the grounds. And yesterday, my learned friend has placed the ruling before the honorable court that this honorable court has to proceed strictly in terms of the pleadings made in the plaint or made in the appeal. So I'm repeating again that while considering this appeal, that principle should be followed strictly, keeping in view of the prayers which they have taken in the present appeal. What prayer they have made in the present appeal. And if something is done beyond the prayers, there is well-settled principle of law, it's very clear that relief should not be given beyond the prayers. Beyond the pleadings, court should not travel. All these principles we should keep in mind while considering this lordship. Now, coming to the ambient order, which they have challenged. And yes, there are few points which I would like to clarify. I will not take your lordship to each and every pages. Kindly come to page 156.
One,
5.6. This is a portion of the ambient order. Paragraph 4 of the judgment. Has your lordship got it?
yes.
1, 2, 3, 4. Fifth line from the middle, from the top, paragraph 4, fifth line towards the middle of the page. The sentence starts with accordingly.
Yes.
Yes. Accordingly, this court issued directions to the parties to submit a list of witnesses whom they wish to examine and also to furnish any documents the parties are interested to file in this regard. However, none of the parties submitted any fresh documents or introduced any new witnesses, but instead conducted further examination of previous witnesses. Respondent produced and further examined respondent number 2, Shri Satutu Tui, and Mr. Sanyo Kizo deposed himself as RW3, who were cross-examined by the plaintiff. The plaintiff further disposed himself as PW1 and also produced Kututu Vero of PW2, who were cross-examined by the defendant, and thus giving full opportunity to the parties and disclosed the evidence. This court, while taking into consideration the issues framed, this court marshaled the evidence and the parties and also examined the records and documents and accordingly disposed issues issue-wise as under. So, as per the direction given by this honorable court, the trial court has also proceeded according to by affording opportunity to all the parties for furnishing document, exhibiting document, to examining witnesses. To that extent, ample opportunity has been afforded. So, when full opportunity was afforded, what is to come in this appeal with a grievance that the judgment is wrong? If they want anything else, they should have asked at appropriate time. They got the full opportunity before the
One
trial court.
submission that Mr. Iralu made yesterday was that even though they didn't objected to admissibility of some documents like Exhibit A and B, but this court has to see that whether they are otherwise, if they are inadmissible, they cannot be acted upon. That was his submission.
That was his submission. That is why, where he has raised that objection.
He said that he did not raise.
And Lordship is well aware that original documents have been lost. Now, the other documents, in absence of any original document, under the law of evidence, secondary evidence can also be taken as admitted. Now, by filing the present appeal, the main thrust, the main point which they have raised is Exhibit A, which is at page 110. Photocopy cannot be admitted without producing the original documents. And then they have a grievance that no effort was made by the trial court to produce original copy and no reason has been given. Now, whether that opportunity was given or not, can we come to issue number 3, paragraph 8 of the judgment.
Page.
Page, it should be 158. Has your lordship got it?
Yes,
May I read through?
yes.
Issue number 3. Whether the disputed plot of land was actually sold to the present respondent petitioner. If so, why he was not implicated as party to the proceedings. As regards this issue, Sanyo Kezo has claimed to have purchased the suit land from Mr. P.D. Chibi in 1969, with further contention that the suit land was sold to P.D. Chibi by Sri Tachuni and Vichuni. However, in this regard, there is no documentary evidence exhibited by Mr. Sanyo Kizo. See, to prove his stand. Rather, while going through the declaration, Exhibit A, it reveals that Sanyo Kizo purchased the plot from late Hutsuto, where he has constructed his house, but the suit land belongs to Kiriti Viro, which is the adjacent to the plot of Mr. Sanyo Kizo. Further, the records reveals that though Sanyo Kizo is claiming to have purchased the suit land in 1969, but there exists a question as to why Senyu Kizo slept over the matter for about 10 years when dispute over the suit land started in 1975. His plea that he was not aware of the dispute over the land adjacent to his own plot inspires not much confidence worth relying upon. It also reveals from the records that Shri Tachuni and Shri Pichuni was having dispute with regard to the suit land with Mr. Keretiviro, who has filed application claiming ownership of the suit land before STO Civil in 1984. Whereto, Senyu Kizo was not a party to the said dispute. As such, it gives rise to an inference that Mr. Tachuni and Mr. Pichuni have not established their ownership over the suit land, and therefore selling off the suit land to Mr. Piri Chibi, who in turn sold the suit land to Mr. Senyu Kizo in 1969, is a contention hard to accept. See, very clearly. Further, I'm proceeding further, Lordship. Further, this court has also taken into consideration of the factum that during proceedings, Senyu Kizo has not exhibited any sale debt to substantiate his claim. These are very important facts, Lordship. Senyu Kizo has not exhibited any sale debt to substantiate his claim. 2. Mr. Vichuni, while deposing as RW number 1 in previous proceeding, have testified that sale deed agreement may be there, and Mr. Senyu Kizo as RW number 3 have categorically testified that sale deed agreement was executed and cannot be produced and can be produced as and when necessary. However, no sale deed was produced and exhibited while trying a case afresh again by this court. This is also very clear. The only evidence adduced in support of the claim of Mr. Senyu Kizo are the testimony of RW1, Mr. Vichuni, and RW2 Satahu Tuni. The veracity testimony of respondent RW1 Vichuni is doubtful and unreliable for the reason that if he and his brother Tachuni have sold the land in 1969, why have filed application claiming ownership in 1984? See, on the other hand, his brother, Mr. Tachuni, has given lived written document supporting the ownership of Mr. Keriti over the suit land, that is Exhibit A. The document stood unrefuted. Can we say that no opportunity was afforded? They were given full opportunity. Further, the testimony of RW2, Mr. Satahu Tuni, is merely a narration of incident he observed when he was a child and about 10 years. Even otherwise, assuming the testimony of respondent number 2 to be true, it does not, in my considered opinion, establish the claim of Mr. Senyu Kizo. In compliance with the order and direction of the Honorable High Court, this court has proceeded from the stage of evidence and accordingly recorded the evidence of the parties. However, while marshalling the evidence, this court does not find any credential evidence to infer that Senyu Kizo has ever purchased the suit land, and in the absence of such evidence, this present issue is decided in negative. And then about the earlier litigation has been mentioned there. Now, another point they have raised in the present appeal is the appellant is in possession of the land. So this issue has been discussed in the paragraph 12 and 13 of the impugned order. Under issue number 7 and 8. Page 162. May I read, Lordship? Under paragraph 12. Prior to the sale of the disputed land, Shri Tachuni and Vichuni were the real owner of the land. As such, the present plaintiff respondent has no locus standi. The present suit is pending between Kereti Bureau and Senyo Kizo. Needless to mention that the matter in issue
What was the issue here? What? question
issue
is?
number 7. Issue number 7 is prior to the sale. It is same issue. This is the issue.
But it appears that it is an answer, not a question. You read
Yes. Exactly, Lord. We can go to issue number 8, page 13, paragraph 13. 163.
it. Yes.
Whether the flood of land prior to emplatement of the present respondent as a party is distinct from the present plot of dispute, plot in dispute, because this was the issue, this area, that area. Numerous litigations from time to time were instituted by the parties before various forums, including the Honorable High Court, wherein the subordinate courts, including the Honorable High Court in Civil Revision number 13K of 1992 and Civil Rule 174K of 1992, have also come to the conclusion that the subject matter of the present suit is the land where the Senyu Kizu have constructed building in violation of the order of the Honorable High Court. Further, the evidence adduced by the parties does not reveal that the land in question in the present suit is a distinct plot of land and not the present disputed plot of land. So this is also clarified. Now, another issue which they have taken is the learned trial court ought to have identified the disputed land. That is also one of the grounds they have taken in the appeal. Now, in this connection, I would like to cite and refer to one of the applications which they have filed before the learned trial court. Before the district judge pack, it was filed under section 75 of CPC, read with order 26 rule 9. An application was filed before the district judge pack under section 75, read with order 26 rule 9,
Commission.
which was rejected by the trial court. 115. Huh? Lordship will find the application at page 118. And this is the application 118. And prayer, Lordship will find at page 119. And the order, Lordship will find at page 115.
115.
115 is the order passed by the learned trial court. It is order dated 6/9/2018. That's your Lordship, Kari?
Yes.
May I read, Lordship? The applicant Sri Sanyu Kezo has filed an application under section 75, read with order 26, rule 9 of the CBC, praying for issuing commissioner to make local investigation regarding the location of the post office, which once existed within the vicinity of the land and dispute. The application has been filed to identify the suit land as the respondent herein has been claiming the ownership of the land in which the applicant has already constructed the standing building. In this regard, the counsel for the applicant has drawn the attention of this court Annexure A, report dated 19/6/75, submitted by PA to DC to the Extra Assistant Commissioner Potsoro. The relevant portion of it shows herein that a small portion opposite to the present post office on the front side went in favor of Keriti, the respondent opposite party in this present application. 2. The learned counsel for the opposite party contended that the issue with regard to the location of the suit land has already been settled by the Honorable High Court in Civil Revision 13K of 92 by its judgment dated 29/6/1993, wherein the Honorable High Court has observed and held that the land where the present applicant has constructed a house is the suit land. As such, the location of the land in dispute is no more an issue to be deliberated at this belated stage. How they are playing tick one after another. Paragraph 3. The relevant portion of the judgment of the Honorable High Court in the Civil Revision 13K of 92 is reproduced below. It appears that on careful perusal of the order dated 27/10/77 passed by the ESC Potsoro, by which right was declared in favor of the petitioner and also civil case number 48/85 filed by respondent number 1 before the Court of Additional Deputy Commissioner Judicial at PAC against the aforesaid order of ESC in respect of the same subject matter, para 7. Such dispute should be resolved once and for all, as stated above. Instead of resorting to normal process of law, the respondent number 1 resorted to a legal method of frustrating the judicial process by constructing house on the disputed land during the period from the date of direction. It is made clear that in view of the finding above in respect of the action of the respondent number 1, construction of the building shall be deemed to have been met at the risk of the respondent number 1. Therefore, if he fails in the suit, respondent 1, that is Sanyu Kezo, shall not be entitled to claim any compensation for vacating and removal of any construction that has been erected on the suit land, that is from para 10. On perusal of the records, it transpires that the present suit is pending trial for the last more than 40 years before various forums. And as admitted by the parties, the present application has been applicant has been a party to this suit since 1985. However, at no point of time during the proceeding before the different trial courts, the location of the suit land was an issue, whereby prayer was made for intervention of the court for such direction to identify the location of the suit land. More so, the Honorable High Court in its judgment mentioned herein above has held that the land where the applicant has constructed the house is the suit land. Hence, I see no justification, reasonable ground in conducting local investigation by a commission to ascertain the location of the suit land at this stage, as it shall only result in delay of the matter and shall also go against the ends of justice. So in view of this, the application has been. In view of the above, I hold that the appointing commission for investigation regarding the location of the suit land as prayed for by the present applicant is not maintainable. Accordingly, the present application in civil will be dismissed. It was passed on 6th of September 2018 by the District Judge Heck, Lordship. Now, another aspect, Lordship, you can see. Page 52. All documents are the documents enclosed in the appeal by the appellants.
Yes.
Fifth line from bottom. The sentence starts with Mr. Charukopal Singh.
Yes.
Has your lordship correct?
Mr. Charu Gopal Singh.
Yes. Has strenuously urged before me to bring home the fact that the land in the present petition is different from the land where the construction has been made. See, the same issue has been raised even in all the subsequent proceedings. It appears that on careful perusal of the order dated 27/10/77 passed by EAC Potsuro, by which the right was declared in favor of petitioner, and also civil case number 48 of 85 filed by the respondent. One, before the Court of Additional Deputy Commissioner Judicial Fact against the aforesaid order of EAC in respect of the same subject matter. I am not inclined to accept the submissions made on behalf of the respondent number one in this regard. This is very, very important because they have not filed any appeal against this observation also. Therefore, the appellants are stopped from raising this issue in this proceeding or for that matter in any other proceeding.
This observation was in which proceeding?
Made in civil,
By High Court.
yes, by the High Court in civil revision number 13K of 92 and civil roll number 104K of 92. By a command judgment, the order was 29/6/1993. The order judgment is starting from page 45. So far as this point is concerned, this honorable court has already decided, and no appeal has been filed against this finding. Therefore, they are stopped from raising, and no reliance can be made on this point because there is already a decision. They have accepted the judgment. No appeal preferred, so they are stopped to raise that point again and again because they are trying to find a new avenue to prolong the matter so that they will enjoy the rent under disputed land. That is the motive I could notice from various actions the appellant has taken. This was already decided by this honorable court on 29/6/1993. And also, Lordship, you can see page 150. This is the deposition made by the parties before the District Judge Pack 150 by the appellant by Sanu Kizo in Civil Revision number 1 of 2001.
Yes.
This has been stated during the cross-examination. Kindly see middle of the page, cross is shown, and from the bottom, third paragraph.
It is correct.
It is correct. Yes, Lordship is correct. It is correct to state that I have constructed a building over the suit land. However, I am not so sure about the year when the building was constructed, but it might be after 1985. I have constructed the building without the direction of any court order. Rather, it is in violation of the court order. Court has directed not to file a suit. If at all you have any cause of action, you file a suit. Instead of filing the suit, he went ahead and then started construction because he was the officer in charge of the Butsuro police station. Taking the law into his own hands, he has constructed the building, and he himself has admitted to the fact that he has constructed the building in the disputed land. What more evidence do we require when the person himself is admitting the fact that the land, the disputed land is the place where he has constructed the building.
Whether there was any stay. Some injunction was there, no.
No injunction was there.
So
Rather, a fine of rupees 2,000 has been imposed on him
why?
for violating the court order.
What was the court never said that don't go.
High Court has passed an order not to develop. He has
Oh,
developed.
that order was there.
Therefore, yes. When the person himself is admitting the fact that he has constructed the building in the disputed site, the question of another floor doesn't arise. He is admitting the fact that yes, in the disputed land, I have constructed. So what is the point? What is the question? To look for another plot, another dispute. We are talking about this land only, not any other land.
Suit land. He used the word, it is correct to say that I have constructed a building over suit land.
Yes. And he is saying that not that construction is not in terms of the court order. Court will not direct anybody to construct a house. But then in the cross, we wanted to see that whether you have really violated the High Court order or not. That was the question board. He has said that yes, I have constructed, but that construction is not under strength of any court order. I have just constructed on my own. That is what he is saying. So when he himself is admitting that he has constructed the building in the suit land, where is the point and question of looking for another plot? Or why, where is the point to mix up with another plot? When the person himself is admitting the fact that this is the disputed land. Land do not have leaks. They will not walk from here to there, nor they will come from there to here. Land, it will remain as it is. Ownership may change. That is why.
But had there been a proper plan, had there been a proper plan with a proper schedule where land is properly described,
that would have been raised about 40 years back.
yes.
Otherwise, even after 100 years, we can take out so many procedural lapses also. I can give also 101 reasons for that matter. But we are trying to establish who is the real owner within the parameters of law, within the keeping in view of the different orders passed by the Honorable Court, as well as by the court below. So the same float, the same land, this Honorable Court has arrived to a finding that this is the one, and the one which they are trying to complicate by showing another, projecting another float dispute site. That is irrelevant. That point has already been rejected long back, way back in 1993. And in the latest trial, the person himself has admitted, confessed himself that yes, I have constructed in the disputed site, constructed the building in the disputed site. So where is the point to go for another evidence? Therefore, Lordship, the learned trial court has conducted a trial strictly in terms of the direction passed by this Honorable Court, and ample opportunity has been afforded to all the parties, either to adduce evidence, to produce any documents. And this proceeding is a proceeding which was pending before the Additional Deputy Commissioner Judicial Kohima. Of course, it was on transfer from PEG. And Lordship has seen the proceedings before the Additional Deputy Commissioner Kohima. Record was lost. So parties were directed to file fresh evidence, fresh notes, fresh documents. That was also done. This is a continuation. So the question of not filing written statement, the point which my learned friend has raised is baseless, because this is not a fresh suit filed in the PEC, but it is a continuation of earlier proceeding, because no fresh plaint has been filed and there is no direction by this honorable court also. Only the pending application is to be decided by allowing the parties to examine the witnesses, and if at all they want to adduce any documentary proof, then that was allowed. Liberty was given. Everybody was given full ample opportunity. So where is the grievance? Yes, one may try to pick here and there the technical approach. Even a typing mistake will be a ground. But my prayer is, Lordship has seen the entire facts and factum of the case, assess the merits and demerits in the case, and arrive to a reasoned conclusion by weighting the merits of the case, not looking at the technicalities of the issues. And taking into consideration of the grounds which they have taken, it is none of the grounds are sustainable in the eye of law. Therefore, the present appeal deserve to be dismissed. And coming to the application which they have filed under Order 41, Rule 27, where they wanted to annex a document of 1962. We have filed a short reply to that. I may be allowed to refer to that reply. The application which they have filed in this present appeal under Order 41, Rule 27. So a short reply, just few paragraphs, I may be allowed to read. Written objection. It was filed on 14/8/2019 in IA 84K of 2019.
Yes.
Kindly come to page 2, paragraph 2A. From A to F. May I read, Lordship? That the present case between the appellant and the respondent has been agitated in the various courts for more than 34 years. 34 years is after Senyo Kizo joining the case. And various orders has been passed to that effect. However, despite the span of time and the filing of number of cases in different courts in connection with the plot of land in question, and at the time of taking evidence, the present appellant failed to produce any documents in support of his claim, and as such, on the basis of the available documents as well as evidences, the ambient order dated 17/5/2019 was passed by the district judge Peck. Before this, another trial was there by the ADCJ Kohima. B, that after the ambient judgment and order dated 17/5/2019 was passed by the district judge Peck, the appellant has preferred an appeal being first appeal number 2K of 2019 against the aforesaid judgment and order dated 17/5/2019 which is pending before this honorable court. When the matter is pending before this honorable court, one court is missing word. The appellant has filed the present interlocutory application under Order 41, Rule 27 of the CPC to produce agreement dated 15/11/1969. The said agreement dated 15/11/1969 is for the first time producing before the appellate court after more than 34 years of dispute between the appellant and the respondent in various courts. C. That in order to allow additional evidence before the appellate court, firstly, the appellant must satisfy the conditions laid down under Order 41, Rule 27 of the CPC, which provides as follows. Production of additional evidence in appellate court. 1. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, if the appellate court, but so they want to avail the exceptions. But if A, the court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted. A. The party seeking to produce additional evidence establishes that notwithstanding the existence of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appeal against was passed. Or B, the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. The appellate court may allow such evidence or documents to be produced or witness to be examined. 2. Whenever additional evidence is allowed to be pronounced by the appellate court, the court shall record the reasons for its admission. Now, in this connection, it is important, Lordship. It is stated that in order to adduce additional evidence documents before the appellate court, one must fulfill the above mentioned criteria laid down under Order 41, Rule 27 of the CPC. However, in the present case, the appellant is filing the present application seeking the leave of this honorable court to bring into record of a document after more than 34 years of litigation between the same parties. The appellant was given enough opportunity to produce these documents when the matter was pending at different forums for the last more than 34 years. Admittedly, the appellant was not diligent and omitted to produce such document, which was within his knowledge for the last more than 34 years. Now at this belated stage, if this document is allowed to be produced before this appellate court, there will be never-ending litigation, and as such, this honorable court may be pleased to reject the present application for the ends of justice. D. That the applicant has produced an agreement dated 15/11/1969, allegedly executed between Pechuni and Biri, wherein it is stated that in the year 1969, I, Mr. Pechuni, has sold my plot below the dispensary facing towards the road to Mr. Piri, and there is no dispute over the land at Rupees 460. The said land was resold to Sanyo Kizo by Piri on 4/12/1969. The said agreement is produced below. I, Piri, on dated 15/11/1969, purchased land from Pechuni Vero and dispensary plot facing towards the road, had resold to Sanyo Kizo at Rupees 460. There is no dispute over the plot of land. Appear perusal of the said agreements, because whatever I have read is the text agreement, which they have been closed. There is no dispute over the land. Appear perusal of the said two agreements. The location of the plot of land sold to Piri by Pechuni and a plot of land that has been allegedly resold to Sanyo Kizo is different. Therefore, this honorable court may not allow such conflicting documents to be produced before this honorable court. E. That as regards the disputed land, the respondent white letter dated 10/5/1972 has submitted an application to the Director of Health Services, Nagaland Kohima, praying for acquisition of all dispensary quarter type 3 at Puchuro. In the said application, it is stated that now the quarter is vacated by your department since the last year, that is 1971, and the building is now in a dilapidated condition as repairing is not undertaken. A land certificate was also issued by the GP of Kekromai village as well as EAC Puchuro. From the above facts, it is clear that the said dispensary was vacated only in the year 1971. F. That even assuming that there exists an agreement dated 15/11/1969 between BD and Sanyo Kizo over the disputed land, the same is null and void because of the fact that when the said agreement was entered between the parties over the said land, the same was under the possession and occupation of the Department of Health Services. That is till 1971. And they are trying to show a document which is of 1969. In view of the above, the present interlocutory application for production of additional evidence document is not sustainable in law, and as such, the same may be dismissed. Even the appellant is not clear about the flood, and when the land was vacated in 1971, there is no question of selling the land in 1969.
Otherwise, it is not a sale deed, it is an agreement to sell.
Yes. But then they just want to buy time. That's how, as far as possible, they want to complicate the issue so that they can find a way to send it back to the lower court for trial or to enjoy the property over the suit land. That is the only reason I could gather from the conduct of the appellant over the years, Lordship. Now, since time is already run out, but by and large, I have already completed my submission. I have few citations. I will place that, and I may be allowed to file a chase-up argument also, so that that will be a reference. Of course, Lordship may or may not rely on that, but then chase-up.
Let us stop here.
All right. Yes,
Tomorrow we will continue,
Lordship.
because now you have to only show citations.
Lordship, yes.
And Mr. Iralu may have some reply also. You
Yes,
want
sure reply.
reply.
Yes,
You were to give bullet points also.
Your Worship.
Tomorrow you may give.
Uh,
Will it be possible tomorrow?
if not tomorrow, then Friday in the
Friday.
first hour.
Because Friday I'll be leaving.
Before you leave, Your Worship, we can submit. That is, if we cannot submit tomorrow. By any means, Friday morning.
Best option would have been in presence of both the parties if bullet points were given.
Yes.
Yes.
By and large, submission has already been made by both of us. So let him reply tomorrow and I will cite some citations. My citations are very few, unlike my learned friend.
So we will take it up tomorrow when you suggest. At
Tomorrow at the earliest, in the first hour itself.
the first hearing.
So far as I'm concerned, I will not take more than 20 minutes, Lordship. Tomorrow.
As the first hearing item,
Yes,
because otherwise, if other matter comes up, again it will be late.
yes.
Heard Mr. C.T. Jamil, learned counsel for the respondents. Also heard Mr. R. Iralu, learned senior counsel for both senior counsel for the appellant. Mr. Jamir is assisted by Mr. N. Longkumar and Mr. Iralu is assisted by me, Mr.
Ilivil Zhao.
Ilavi, Elivio. I have to look at the
in the immune judgment also it is there.
Eliville Zhao,
Yes.
Eliville Zhao. Hearing remained inconclusive. Let this case be again listed tomorrow as part third matter as the first hearing item.
Yes. Much obliged. Risab Kurabali, Jagina Kurago Palace. Otherwise, other ordinary days, the 1.5 hour I. Like.
Okay. Okay.
Whatever.
Computer section, court khatam hoise de, court 2.